For the first time, SOLPO, I'll just give a 2 minutes introduction. SOLPO is an independent organization for thought and leadership in areas of law and policy. We had set up this research organization sometime 4 years ago, but we never had the time to really to grow it, and we never invested enough time. COVID was a blessing in that sense. We were able to work and do some work in this area. We are looking at some sectors. One of the sectors that we're looking at is water going forward. We want to look at water, which is critical, and look at regulation, laws, policy, and a national water grid and things like that. We'll come back to that. But for today's seminar, the legal ecosystem of tribunals and regulatory bodies. Before I introduce our very esteemed guests, the panelists, Mr. Vaidyanathan, Mr. V.P. Raja, Mr. Tathagata Satpathy. Before I do that, I just want to give a background as to the context of what we are proposing to discuss. And one caveat that this is not a one-off seminar. It's like something we want to continue hosting to narrow down issues and to bring some of these issues in the forefront so people feel comfortable in discussing things which are otherwise not very comfortable, especially for lawyers and many of us who work in the system. There are many questions that arise. Now, just for the audience, we have over 90 people who joined in now. So for them, and even for my friends, the younger people in the bar who have also joined in, I want to just give a background as to this distinction between court and tribunals. The Supreme Court in 2010, in a judgment, the Madras Bar Association said this in para 12. The term court refers to places where justice is administered or refers to judges who exercise judicial function. Courts are established by the state for administration of justice, that is, for exercise of judicial power of the state to maintain and uphold rights, to punish wrong, and to adjudicate upon disputes. Tribunals, on the other hand, are special alternative institutional mechanism usually brought into existence by or under a statute to decide disputes arising with reference to a particular statute or to determine controversies arising out of administrative law. Courts refer to civil courts, criminal courts, and high courts. Tribunals can be either private tribunals, arbitral tribunals, or tribunals constituted under the Constitution, Speaker or the Chairman acting under para 6 of the 10th schedule, or a tribunal authorized by the Constitution, administrative tribunals under Article 323A, and tribunals for other matters under Article 323B. All statutory tribunals which are created under a statute, Motor Accidents Claims Tribunal, Debt Recovery, Consumers Forum, etc. Some tribunals are manned exclusively by judicial officers, rent tribunals, motor accidents claims tribunals, labor courts, industrial tribunals. Other statutory tribunals have judicial and technical members, administrative tribunals, TDSAT, competition appellate, consumer forum, cyber appellate tribunal, etc. Now, this is the broad distinction under which the tribunals have been recognized, and they are currently, it's something that we engage as lawyers and professionals on a day-to-day basis. Now the court went further and then said that there is something called a regulatory body which may not be a tribunal per se, something more. And this is how they define a regulatory body. This is a Cellular Operators Association. Mr. Vaidyanathan was involved in this matter. It was 2003 judgment where the Justice Sinha in para 33 says, regulatory bodies exercise wide jurisdiction. And this is interesting. He says, they lay down the law, they may prosecute, they may punish. Intrinsically, they act like an internal audit. They may fix the price, they may fix the area of operation, so on and so forth. While doing so, they may, as in the present case, interfere with existing rights of the licensees. So there you have a tribunal, you have a court, and then you have a regulatory body, which is more than what a normal traditional court can do. Now, in this background of courts and tribunals, the Supreme Court has raised questions about independence. And that is the heart of today's discussion as to how successful has this experiment of having tribunals, which is here to stay. All subjects have tribunals. And what the Supreme Court says in, again, Madras Bar Association 2010, para 70, but in India, unfortunately, tribunals have not achieved full independence. The secretary of the sponsoring department concerned sits in the selection committee for the appointment. When tribunals are formed, they are mostly dependent on their sponsoring department for funding, infrastructure, and even space for functioning. The statute constituting tribunals routinely provide for members of civil servants from sponsoring department becoming members of the tribunal and continuing their lien with their parent cadre. Unless wide-ranging reforms are implemented, reforms as were implemented in United Kingdom and were suggested in L. Chandrakumar's case, 1997, are brought about, tribunals in India will not be considered as independent. Now, similar thought and views were made by the Supreme Court as late as 2019 in the Roger Matthews case, where they explained the difference between independence of an individual judge, that is decisional independence, and independence of the judiciary or tribunal as an institution or an organ of the state, that is functional independence. So they made that difference and then said protection from interference and this is 2019. Protection from interference and independence from the executive pressure, fearlessness from other power centers, economic and political freedom, power centers, economic and political, and freedom from prejudices acquired and nurtured by the class to which the adjudicator belongs are important attributes of institutional independence. Now, today, in this context, I have the pleasure of welcoming three very eminent persons who are involved in various facets of this ecosystem of tribunals. Mr. C.S. Vaidyanathan, a senior advocate who's been a guide, kind of a guide and a mentor to many of us. Mr. Vaidyanathan became a designated senior in 1992. That's the time when I joined the bar. So he's a super senior for all of us. And we always looked up to him for guidance. Mr. Vaidyanathan was the additional Solicitor General of India in 1998 and 1999, that period. And he's one person who's seen the entire spectrum from the top court right to all kinds of tribunals, whether it is the telecom, broadcasting, power, mines, airports, electricity. He's been there, the IBC today, and also in terms of NGT. And apart from all this, he's also seen the court functioning. So therefore, we need his input to show us as to how this whole tribunal ecosystem has survived over the years and what are the flaws that he sees when compared to a traditional judicial system. Mr. Vaidyanathan has appeared in several of the interstate water dispute, and so we'll come back to you on that in a separate seminar or even privately, because we are looking to work on that sector. which includes the Kaveri dispute, the Ravi, Bias, Narmada, Krishna, all these disputes, these tribunals, Mr. Vaidyanathan has been part of it. And then, of course, recently in the Supreme Court, he was a lawyer for the DT, Ram Lala, in the Ayodhya matter for Ram Lala, and then he's also appeared in the Ram Setu matter, and also he's argued that Sanskrit should be part of the CBSE schools. So this is the background, and we will come back to him for his views on some of the issues that I've highlighted. Mr. VP Raja is an Indian Administrative Service officer, 1974 batch, and from Maharashtra, Kada. Mr. Raja has my first meeting with Mr. Raja was when he was chairman of MERC, and this was between 2008 and 2013. Before that, Mr. Raja was principal advisor to the Department of Atomic Energy, Government of India. He is a student of physics. So Mr. Raja was in St. Stephen's College, his BSc Physics, MSc in Physics, went to Columbia, got a further degree in Physics. Then he has a degree in Rural and Development Planning from Norwich in the UK, University of East Anglia, and also from the University of Punjab. He has an MPhil in Social Sciences. Apart from holding various positions, Mr. Raja has been teaching. And this is very fascinating because he's always been teaching while he was serving as a bureaucrat. And he's been teaching, today he takes classes in the Jamnalal Bajaj Institute. He teaches in the BARC training school on nuclear fuel complex in Hyderabad, World Trade Institute, and the Yashwantrao Chauhan Institute of Development Administration. We will get back to Mr. Raja on some of the issues because he's been a regulator who has had to deal with government and has some very strong views on the subject. And I know that with my interaction with him over the years. Mr. Tathagata Satpathy is like an elder brother to me. Let me just put that in the context. And I go to him for almost everything that I need in life. I use him for his wisdom. He's been a 4-time parliamentarian. He's from my state, from Odisha. And he has been in the 12th, 14th, 15th, and 16th Lok Sabha. And he has strong views and very independent views. And now the official statement is he's taking a break from politics. And he's a journalist. He has 2 newspapers and he edits and owns one of the highest selling newspaper in circulation, Dharitri in Odisha, and an Indian and an English daily called the Odisha Post. It's Odisha Post. He's not changed the name to Odisha. And having said that, what is fascinating is that he has taken a lot of issues in Parliament which normally a politician would not take up. One is his views on net neutrality. He was the first parliamentarian to write to the TRAI expressing his views on net neutrality. He came forward with the consultation paper and he then wrote an open letter to TRAI stating his support on net neutrality. Apart from this, he's taken very strong views on legislation of cannabis. And he has taken this view in Parliament where he has said that he's criticized the ban on cannabis in India. He has said addiction depends on a person's character and not on the cannabis or the intoxicant. He has also said that in the past that there is an elitist bias. If you want to stop people from getting high on something, stop alcohol, because in villages that is a bigger problem than use of cannabis. He has taken views, he has made very strong views in Parliament on decriminalization of homosexuality before the Supreme Court stepped in 2018. This was way back in 2015 when he supported a bill piloted by Shashi Tharoor and which finally failed in Parliament. Then he has views on privacy, on Aadhaar, and other strong views. And there's a lot of material on him which I can go on and on. But going back to the subject, what we are looking at from our esteemed panelists is to answer some of the question that arises in the context of tribunals in India, keeping in view the fact that the Supreme Court has red flagged that there is an issue, but the issue is not getting addressed, neither through legislation or policy. It's just it's just business as usual kind of a approach. The issue is about lack of independence. What are the shortcomings? Is there a better way of appointment? Is there a tribunal kind of a cadre that we're looking at, which can a national cadre from where you can fill in the tribunals? Should you have a separate appointing authority like the UPSC or things like that? Or can you still continue to have secretaries to government sending members to tribunals and then trying to have some control over them through the back door? Then there are issues about I'm sorry, there's some about the regulatory bodies which have been given the power, and this Mr. Vaidyanathan will also weigh in, have the powers to make laws and also the powers to enforce that law. So in the morning they make a law, pre-lunch. Post-lunch they enforce the law they made. Where does separation of powers stand? So these are the broad issues. I know that it's a 1 hour limited seminar. We want to raise these issues. Then come back with some questions from the people who are the attendants, from the attendees and our guests. I thank everyone for joining us. We look forward to your comments. If you're able to take everything together, it's fine. Otherwise, we will set up a protocol to exchange ideas. And that's what SOLPO is for. We want to create a debate which is ongoing. I would now request, the format is the following. We are requesting our panelists to give a 10 to 15 minutes opening speech and opening remarks, after which we open the session for discussion. We get in our guests to ask questions. The questions can come to a chat box, or if they want to say it themselves, they can give us through the chat room. We will unmute, and then we can have a question answer session. May I now request Mr. Vaidyanathan to first open the comments and his remarks on what SOLPO is trying to flag and how relevant is it in today's context.
Good evening, ladies and gentlemen. It's a pleasure to be with you all this evening. I have known Mr. Sanjay Sen for at least 2 decades now or more. And we have appeared together and we have appeared against each other, and it's always a pleasure to appear in the court. Mr. Raja, I've never had the pleasure of appearing before him as either as a chairman of MERC or otherwise knowing him, but I have known him through his orders in MERC, some of which I have had to deal with. And I think he is an ideal kind of a tribunal chairperson. And unfortunately, we don't have too many of them. Mr. Satpathy, I have not really heard, but I have read in the newspaper about his speeches, about his interventions and the independent views that he propounds. And I'm very happy to be in the same panel as all of you. You know, I start with a caveat. I'm not a great fan of tribunals or tribunalization. To start with, I felt it was more of a sinecure for retired judges and retired bureaucrats. And the disenchantment has only accentuated over the years. I would have preferred the high courts to have more judges, more specialist judges, more divisions dealing with technology, infrastructure, intellectual property, and the kind of things. And see, most of the tribunals are created by special statutes. The litigation arises out of new statutes, new acts, and giving certain rights. And most of it is created as a result of the regulatory interventions themselves, unfortunately. But today, with all the past constitution bench judgments and with this stand of the government, tribunals are given. I don't think there's going to be any change. And there is no systematic attempt to root out and reduce litigation. The approach, it's all good to talk about more governance and less government, but I think what we see is more government, and that means promotion of litigation through the bureaucratic approach that unfortunately has been taken. And therefore, tribunals are going to be there, lawyers are going to thrive, the professionals, in a sense, may be happy that it gives rise to so much of litigation. But I don't think that's a good sign. Now, some of the issues that have been flagged, I think are well known, have been debated. I personally feel that asking the tribunals to be headed or having members who are retired from the courts or from bureaucracy is not the right thing. If you if there is no alternative to tribunalization, we must have an organized cadre of persons who would man the tribunals. And they should be recruited at around the age of 40 to 45, and they should have a long enough tenure. One of the biggest banes of this tribunal system is when you have retired personnel manning it, who have a tenure of 3 years and 5 years. Number one, the temptations are too much. One, at the stage of retiring as a judge or as a bureaucrat from government service. Therefore, people aspire for office. Therefore, what happens during those last few months when a person is about to retire as a judge or as a bureaucrat, I think nothing much needs to be said. Everybody knows. Now, if you succumb to such temptation when you become a chairperson or a member of a tribunal, what will happen? Certain amount of influences will continue, and then you have a 3-year period. You don't really get involved in it to that extent unless you have a very conscientious, committed person like Mr. Raja. Not many are like that. That is another unfortunate problem. Therefore, I think we need to have a separate cadre. And why not? Why should persons not go from the tribunal and become a judge of the High Court or judge of the Supreme Court? As has happened in the past, from ITAT, we have had persons going as High Court judges. It is possible for persons to. Therefore, we should recruit members to the tribunal at a very young age. And I think they should be put through an intensive, separate training. The approach has to be different because I think we all have a lot of baggage which we carry from the time we are students and when we are in service or whatever it is. We need to get rid of some of this baggage, unlearn several things, and learn new skills. One of the important things that as a tribunal member should have today is to be familiar with the business environment, because most of these disputes arise in the context of making a business viable and running. And if you do not understand what it means in terms of rupees and paise, what any decision will how it will impact the business, I don't think any tribunal can succeed. Therefore, one is the essentials of finance and commerce. Second, I think is some skills in regard to mediation and negotiation. And when I talk about that, I do not want the tribunals to be looked at only from the point of view of adversarial adjudication. I think the biggest bane of tribunals in India has been that with the judges presiding over the tribunals, their approach has essentially been one of replicating the court system. The procedures, the pleadings, the evidence, the arguments. Why don't we sit on level ground in a conference table and try to find out what is the problem between two sets of parties and try to resolve it? Tribunal should be resolving, not adjudicating. They should essentially be resolving the dispute, not adjudicating disputes. And the problem with tribunals, most of the tribunals today is their approach is one of simple legal adjudication. They are functioning more as extended arms of courts of law. And in spite of the fact that there are technical members, I would have personally preferred high courts to discharge that function. And wherever any special technical input is needed, like in the Patents Act, you have persons who can be called as experts to assist, and or in a water disputes case, assessors are there. That kind of a thing would have been better. But anyway, I doubt very much whether that will happen. But in any case, I think the approach will have to change. It can't be, like for example, I will refer to a case which had its origin with Mr. Raja when he was the chairman of MERC. Now you have in Mumbai a situation where there is more than one operator distributing electricity. So this adjudication has been going on for the last, say, 25 years. It is not going to see the end of the day. It has not seen the end of the day. It is still happening in the appellate tribunal, and it will go to Supreme Court. And there are so many disputes. This is a matter where I am sure with somebody like Mr. Raja, people would have been called, look, what is the problem? What is it? Let us see whether it can be worked out. That would have been what should have been done, unfortunately, has not been done. We are continuing to have this legal arguments instead of trying to, this verbose argumentation, adversarial approach, and procedural technicalities, rather than trying to resolve issues. Like, now the next thing that Mr. Sen had flagged also is the question of the duality of the role. You have, in particular, the Electricity Regulatory Authority, the SEBI, the CCI, even the NGT. NGT is not a regulator, but NGT has some other problems. SEBI, CCI, and Electricity Regulatory Commissions are regulators as well as adjudicators. In the case of Electricity Regulatory Commission, this was a role which was thrust on them, as it were, by the Supreme Court in that SR judgment. But whatever it is, that is the situation. Now, you have the role of a regulator, and in the case of SEBI and CCI, you have them as complainants, as investigators, as prosecutors, and as adjudicators, all roles put together. So much of conflict of interest in respect of each one of these. How can you possibly be a regulator, a complainant, a legislator, an investigator, a prosecutor, and an adjudicator in regard to the same? So one being the Director General Investigation investigates, and then you in the commission, Competition Commission, adjudicate. No, this is a ridiculous situation that we have, and I find it completely unacceptable kind of a situation, but that is the reality. NGT you have. So moto exercise of jurisdiction, National Green Tribunal. So they initiate the litigation as a suo moto process. They get the investigation done. They appoint a team, some retired judges, some retired officers, etc., who will go and give it. And now the affected party will have to argue before them and saying that this report is wrong. This is a committee appointed by the NGT themselves, and it is the procedure followed is a completely something which one would not think any reasonable person would accept. But these are all the problems that we have here. I come next to this administrative control, the functional independence that is required. This issue has been not merely flagged but adjudicated upon by constitutional benches of the court, and the Supreme Court has said that the administrative ministry should not have control over the respective tribunal. But here the situation is only worsening and nobody is making an attempt. It should not even be the law ministry. There used to be, and I am sure even today there is, a Ministry of Justice which used to look after the appointment of judges, coordination at least. And that is the kind of ministry that should be in charge of the tribunal, recruitment and appointment of judges, service conditions, whatever facilities, infrastructure needed, etc. That should be the ministry. Otherwise, if the member of the tribunal has to look for all infrastructural support, facilities, etc. to the administrative ministry, which is one of the party litigant before them, then how do you expect functional independence in regard to that particular tribunal? I think, therefore, this has to be insisted upon, and we need to have this done in the forefront. The court has been pressing for it, and I think we also, the body that which has organized this should actively take this up and intervene in that, and then somehow get this done and point out instances where this has really affected the functional independence of the tribunal. I think one of the important things that since Mr. Satpathy is here and he has been in the parliament 4 terms, I have always been raising this issue. Unfortunately, the parliament, the legislators have not given much importance to this. And I want to use your presence to flag this issue once again. Whenever a law is made, just as you have a financial memorandum on what is the financial impact, there has to be a judicial impact assessment. That is why when you amended Section 138 and introduced 138 of the Negotiable Instruments Act, overnight, 50 lakh cases were added in that year by way of criminal cases for bounce checks, negotiable instruments. Nobody ever imagined the kind of burden that it will impose on the criminal courts. Now, these are some of the issues. Every law, when it is made, it has to be scrutinized thoroughly to see how to avoid litigation, how to avoid issues which will give rise to litigation, the impact that it will have. Unfortunately, there are no specialists here. People who are involved should be selected. Now, I just want to raise one more issue and leave it for further debate. If we have recruitment at the age of 40, 45, the person who should be manning the selection, according to me, with some amount of independence, since this is going to be also resolving disputes, therefore, to that extent, the judicial function of the state is going to be vested in the tribunal. I think we need to have a nominee of the Chief Justice of India to head the selection process. I think the UPSC, which has been doing a good job as a selection body in regard to appointment, I think the chairman or one of the nominees of the UPSC should be part of the team which selects it. And thirdly, I think we need persons who have a sense of business and commerce. And instead of inviting business houses to be part of it, either persons who are specialized in management or some nominee of the institutions of management, Indian Institute of Management or otherwise, somebody like that. So the panel should consist of persons who are known for independence and who have this kind of experience. I think that would be better. There are a number of issues that I would like to go into, but given the limited time, I think we should now leave it to the audience. Thank you. Thank you very much.
Thank you, sir. We have taken note of what has fallen, what you said. And yes, I can only assure you that this is a start, a debate. This is all there in the public space in bits and pieces. We just want to put it all together and then find a direction. And we will come back to you for further guidance on this, how to take it forward. And may I now ask Mr. Raja to give his opening remarks, and then we can go to Mr. Tathagata Satpathy. Before Mr. Raja starts, Mr. Satpathy, apart from responding to issues of the tribunal, I've also requested him to highlight the role of Press Council of India. Because Press Council of India is also a sector regulator headed by a retired Supreme Court judge. And how as a regulator of that area, which I forgot to mention in my opening when I was introducing Mr. Satpathy, that also needs to be hemmed in, because it's a very, very important area in today's democratic, in our democracy today. Mr. Raja, if you can, sir, now take us forward in this, please.
Thank you very much, Mr. Sanjay Sen. It's my privilege to be amongst such eminent personalities and the young lawyers who are listening to us. I will restrict my comments to the regulator function because that's where I have experience. I worked 5 years as chairman of the Maharashtra Electricity Regulatory Commission. About tribunals, etc., I know what normal academics know. But since my live experience is working as chairman MERC, I would like to share more on the regulatory framework. First thing to understand is that the formation or the creation of these regulatory frameworks for various sectors in India really commences after we started economic reforms, after the balance of payments crisis, which brought the country to the brink. I think Jairam Ramesh has written a book, To the Brink and Back. Now that is so till that time, from 1952 till 1990, we had basically followed what is often referred to as the Nehru-Molanabis model of development, learning from whatever we learned and making changes. We started with heavy industries first, the Molanabis model. All these public sectors came up, the commanding heights of the public sector. Then we faced a famine-like situation in the mid-60s and realized we can't ignore agriculture. We faced 3 wars, one with China and 2 with Pakistan in the 10-year period. So we can't ignore defense. Then came the Green Revolution, which did its job of increasing food production, but made huge changes between the rich and the poor in rural areas. We learned from it. So we started this special anti-poverty programs like SFDA and MFAL. Then finally, Garibi Hatao of Mrs. Indira Gandhi in the 5th five-year plan. So we were making changes, but the broad model was that Nehru-Molanabis model. And now, a kind of all the changes were incremental in nature. The real change, occurred with this balance of payments crisis, with Mr. Narasimha Rao becoming the Prime Minister and Dr. Manmohan Singh as the Finance Minister. Of course, some change occurred during Rajiv Gandhi's time when broadbanding of licenses was done. But the real change was this 1990-91 economic reforms. But the crux of the change was, why don't we allow multiple players to operate in every sector of the economy? For producing any good or service, instead of just having one public sector doing it, let us have a public sector as well as 4 or 5 private players. So multiplicity of players. The moment till you only had the public sector, the government was doing everything. Let's say the telecom department was the owner of DOT, the Department of Telecommunications. It was the policy maker, it was the judge, it was the there was only one first corporatization took place with MTNL and BSNL. But when private players start coming in, and for every sector you want multiplicity of players, you needed somebody or some institutions which will ensure a level playing field. As far as electricity is concerned, we found that there is such a strong correlation between commercial energy growth and GDP, and there was an overall consensus amongst economists that a minimum sustained 8% rate of growth of GDP is required for a number of years if we are to cut the vicious cycle of poverty. So if you needed more GDP, you also need more commercial power. A huge amount of power increase took place when NTPC had been formed, when the government of India started getting into power generation on its own. It was realized that even that is not sufficient. We also want private investments if we really have to gear up things. So you invite private investment. The moment you invite private investments, they also want an assurance that if disputes take place, there will be somebody, some institution which will settle the dispute in a fair, transparent fashion. So according to me, economic reforms, the necessity to have multiple players in every sector of the economy, in addition to public-private players, and the need to attract more investments, all this played a part in creating regulators. For electricity, the 1998 Act came. Some experiments have been done with World Bank assistance in Orissa and Andhra Pradesh. Then finally, the Electricity Act 2003 came, providing for regulators in every state and also a regulatory commission in the center. I think it was a good concept. According to me, it is still a good concept. I still consider the Electricity Act 2003 as one of the best pieces of legislation that we have. But what went good, what went not that good, or what didn't happen, what ought to happen and didn't happen, these are not matters of today's discussion. But I must say that yes, I joined the Regulatory Commission after retirement, more or less a few months after retirement. I retired in September 2008 and took over as chairman MERC, I think in November or December 2008, 2-3 months after retirement. Prior to that, I was in the Atomic Energy Commission, from where I retired as principal advisor. But I must say that even though it is a post-retirement job, out of various assignments and jobs that I've done, this 5 years as chairman MERC was an extremely challenging assignment. Extremely challenging. That is the first time I was chairman #1 of a multi-member commission, which is its own kind of judges perhaps are used to be in a bench, but we as officers, IAS officers in senior positions, we have a boss, but when you're secretary of a department, well, your minister is one boss, the chief secretary is another boss. You don't have too many bosses, but in your field, the buck stops. While in a multi-member commission, things are slightly different. It has its own dynamics. Then the commission's role, I still believe after that 5-year experience, or for that matter, perhaps this is true of not merely the electricity sector, but of many tribunals and commissions of various other sectors, I can say that people occupying positions in the commission, either as chairperson or as members, need to be good in law. They must understand the Indian Constitution and the law quite thoroughly, the nuances of it. They must understand economics, which is a very important subject. They must understand, what is a monopoly and what is a duopoly and what is perfect competition. Mr. Vaidyanathan measured in passing to the perpetual conflict between Tatas and Reliance. Now, Reliance have sold their assets to Adani in suburban Bombay, where there are 2 electricity distributors. But monopoly has its own problems. So going away from monopoly to something better, having multiple things is not really competition and yet a step better. You get choice. So there are a lot of economic issues of how people conduct themselves. Many of the conflicts amongst oligopolies or these are related to the fact that everybody wants to become a monopoly. Even today, in the name of private sector, if Geo is going to become a monopoly, there are various issues that is going to happen in the years to come. Let's not forget it. It's not just investment. It's not the deep pockets. It is what is going to happen to consumers 5-6 years down the line when a complete monopoly is established. So regulators in any sector should have a very good knowledge of economics in addition to a very good knowledge of law. They must also have a knowledge of finance. They should understand balance sheets and company accounts and also how it gets dressed up, how it gets, they must have the ability to read between the lines when you analyze 4 or 5 years of balance sheets. Now, a lot of matters today pending before the ISB under the Insolvency and Bankruptcy Code are really issues where you will see huge investments have been made, which have all been kind of, a lot of cushions are there. Somebody, investor is a person, he has charged his return, on that somebody else has charged some other return. So a project which could perhaps should have been of 5,000 crores, a project is shown having 15,000 crores. That much of bidding takes, what you call as cushioning takes place, or feather, what used to be the gold plating of projects. So it is necessary to understand finance. Over and above that, you should have sufficient knowledge of the subject matter so that you're not taken for a ride by people who have spent a lifetime in the technical field. We must respect that expertise and yet understand enough because the so-called subject matter bias also plays a role. So ideally, people occupying the position of chairperson and members of regulatory commissions have to be like Plato's philosopher kings, quite knowledgeable. And they learn. But the point is, there comes. So today, if we analyze the performance of various tribunals and commissions, regulatory commissions of any field, one thing I can definitely come to a conclusion, it all depends on the people occupying those posts. So selection does play a very, very important role. I'm actually reminded when Mr. Atal Bihari Vajpayee was the Prime Minister of India, he had appointed a commission to look into how the Constitution is working. If I remember from memory, Justice Venkatachalaya was appointed to look into how is the constitution functioning? I also recall perhaps a few weeks after Mr. Vajpayee's announcement of forming this Venkatachalaya Commission, Mr. K.R. Narayanan, who happened to be the President of India at that time, in a completely different function, made a very important point. I don't remember the occasion, but it was a few weeks after this was announced by the Prime Minister. He said, the constitution has not failed India. The people running the constitution have failed the constitution. I think this particular statement of Mr. K.R. Narayanan, according to me, is valid for almost every institution in India. It is valid for tribunals. It is valid for the way every institution is functioning, with due respects to the way Parliament is functioning, with due respects to the functioning of the Supreme Court. I don't want to be hauled up for contempt. Prashant Bhushan is already facing contempt. But finally, another thing that comes from this, an institution is built by the people who occupy it. A reputation of the institution does not bestow respectability on the people occupying the position. It is the people who occupy a position who brings respectability to the institution. The performance of the members of parliament brings respectability to parliament, not the other way around. The performance of the Supreme Court judges bring respectability to the Supreme Court. The performance of the members and the chairperson of regulatory commissions bring respectability to the regulatory commission. But basically, after having all this knowledge, what is required of them? What is required of them is basically what can be called a sense of fair play. There is nothing absolutely right and absolutely wrong. In mathematics, you call it a boundary value problem. What is the optimal decision in the current set of circumstances? And can you give the decision with a speaking order? That same decision may become suboptimal 3-4 years down the line because the external circumstances have changed. But as long as you can create faith amongst the people who are dependent on your institution to give judgments, and the people feel that even if the judgment doesn't help them, no, it seems fair. Take it, I will take it on appeal. And then you become a functus officio. You forget what you have done. But the ability to kind of inspire that justice is being done and it also appears to have been done is equally important. Keeping habeas corpus petitions pending for months together loses out on the second point. You lose credibility. Knowledgeable people say, what is happening? What is happening to Article 21? Encounter deaths creates this credibility problem. People are clapping. Chief ministers talk openly that some great thing has been achieved through encounters. They must remember that they have violated the oath they have taken to the Constitution of India. Today, do we have in our country a remedy for people, whether they are bureaucrats or politicians, who violate the oath to the Constitution? I don't know. No PIL has been filed on what is to be done, since we don't have the right to recall in our electoral system as of now. So the point I'm coming to is restricted to regulatory commissions and tribunals, but equally applicable to other institutions. Selection process is very, very important. Easier said, but how to do it? Because whatever is the selection process, you do have the problem, who will police the policeman? As all of us know, the Plato's Republic, which the Catholic Church followed for a very, very long time, and only in 1964, they gave up the doctrine of the infallibility of the Pope. Till the year 1964, the Catholic Church had this doctrine, the Pope is infallible. Only in 1964, during Vatican II, that concept was given up. No, the Pope can also make mistakes. Like we say, the Supreme Court is not infallible, but it is final. In the same way, now the Catholic Church believes the Pope is not infallible, but it is final. So, this issue will remain. Plato's Republic now is criticized a lot. Popper does it best in his open society and its enemies. So in a philosophic sense, we will never have the right answer, but we should try to provide the best we can amongst fallible human beings by providing checks and balances. The best is to have checks and balances. How come that in spite of having a better selection process for the appointment of the director CBI, you had this strange phenomenon of the number 1 and number 2 in the CBI fighting cats and dogs? It raises an institutional issue. It raises an issue that in spite of Supreme Court's intervention, in spite of creating a system which has the Chief Justice, leader of the opposition, the Prime Minister involved, consensus, whatever it is, with all that, you get into a situation where number 1 and number 2 of the most important investigative agency of the country fight and openly fight, kind of wash the dirty clothes, dirty linen in public. This raises again, not as individuals, but as institutions. And the final answer is civic society, people should also be made, should account. And that is why things like, the contempt of court is archaic. If everybody conducts themselves in a lovely fashion, question of contempt of court doesn't arise. But if people don't conduct themselves in what is expected of them, and then want to take protection under contempt laws, there is something going wrong. So there are a number of issues which needs to be debated. Only as a society, all of us are responsible to find better answers for it. I remember Bertrand Russell in one of his books or somewhere says, you can never blame a member of parliament, because if a member of parliament is wrong, the people who elected him and put him there are worse. So finally, the answer has to come through the political process. The political processes may go through ups and downs, but still the correction also has to come through the same political process. I think I will stop at this time for the initial comments. Thank you.
Thank you, sir, for the opening remark. Yes, the takeaway that you have from your opening remark is that finally it is the individual integrity of the person who's manning that office is what matters. And you also say that there should be checks and balances in the system to ensure that the integrity lasts over a period of time. What may be of some relevance to the debate is the legislative gaps in the process or the inertia of the parliament or our executives not to have proper legislation in the appointment procedure, even after the Supreme Court has time and again said that these are the checks and balances and these are the way in which appointment should take place. But those legislations are not coming in place. We'll come back to this in our question answer session. Now I will request Mr. Satpathy to please take us forward. You've heard Mr. Vaidyanathan, Mr. Raja, and with your experience in Parliament, please give us some guidance as to how you look at this parallel judiciary where all economic sectors have been taken away from the normal court that people understand, the civil courts, the high courts. It's gone to specialized forum. And the control of the executive, that's the debate, is quite prominent in this parallel judiciary, and how would Parliament react to that? Because you have legislated this, you've allowed this to happen over the years. If you can take us forward, please.
Thank you, Mr. Sen. I am a little disadvantaged in two ways. First is Mr. Vaidyanathan and Mr. Raja, they are experts and renowned experts in their fields. So it would be difficult for me to match up to their level of thinking and to their pragmatic approach to their fields. And secondly, I've got disconnected 3 times in between, so I missed out parts of Mr. Vaidyanathan's introductory speech and Mr. Raja's speech also. So I'll try to add whatever little I can. See, my experience, I went through 4 governments. The first one was Atal Bihari Vajpayee's government, then 2 terms of Manmohan Singh, and the first term of Narendra Modi. I realized one thing, that when Parliament legislates a bill, it's very interesting to know that many of us who think we study, we refer to the library, and we go and ask the LARDIS, LARRDIS, the legislative the library for Parliament, for details on the bill that is coming. Usually we are given a huge bunch of newspaper cuttings on that subject. It could be from the Hindu, it could be from Times of India, and it could be some op-ed articles, but it's a bunch of newspaper articles. Then if you want to study further, now people go to the net, but otherwise you have to get your own books and read. The problem is, and I'm not trying to cast an aspersion on anyone, most of us cannot read. And, or I would put it this way, a little bit more gentler, that was a bit harsh, I think. Most of us do not find the time to read. Let's put it softer. And another aspect is that if you really ask a minister a pertinent question in the passing of the bill phase, when the bill is presented by the minister, then there is a short phase, depending on who the speaker is or who is on the chair. They give you a little bit of time where you can object or you can ask for a clarification. This is apart from the discussion which may happen a day later or a week later or even in the next session. Or sometimes when the government is in a hurry, it pushes through 5-7 bills while the pandemonium is taking place. But normal times, I'm talking of that, the bills are not even comprehended by the concerned minister. They do not know what is happening. And is to be replaced by and/or. But and replaced by and/or, if you go back to the original bill and you read it, and since there are legal luminaries here, they will know better than I do. It can make a heaven and hell difference for the person who's going to be affected by that bill. And apart from the cannabis legalization, I had a few other private members' bills which I had moved. And one of the important ones that I think you have said very rightly, that cannabis movement, because worldwide it is not just an intoxicant, but worldwide now the medicinal aspect of that plant is being recognized, and it is something indigenous to India. But that apart, I had moved a bill which I thought should bring about a fundamental change, and my idea was in drafting that I had taken help from, if Mr. Sen remembers, I had taken his assistance, also had taken his guidance. It was the speech bill, where I had tried to change the defamation law into a civil law only, because most other Western democracies have only the civil aspect in the defamation law, and the criminal aspect is not there. In India, probably because of our past, colonial past, we have had both defamation in the form of criminal and civil. And when passing that bill, while discussing that bill, it came up for just introduction. It was never discussed because the government did not want to discuss it. And private members' bills, what I have collected, only one private member's bill has been accepted in the Indian Parliament during Jawaharlal Nehru's tenure as Prime Minister. Otherwise, no government ever allows any private member's bills to come up. So that whole exercise, half of every Friday of every week of every session of Parliament, is actually a complete wastage of the taxpayers' money. The speech bill wanted to address not only defamation. I wanted to make a law where if you have a defamation against the media, say against a television network or a news item in a newspaper or a magazine, you don't go to the courts, not the formal courts. You first go to the press council. And the press council should behave like the authority of the High Court. And if you are not satisfied with the findings of the press council, you can go to the Supreme Court. That is what I had tried in that bill. A lot of these lower courts dealing with defamation have very little idea. In a state like Orissa, for instance, defamation is not a very well understood act. What happens is, during one of the former governments, during Mr. Biju Patnaik's government, what he did, he passed a bill that any woman going to court, any lady going to court need not pay the court fees. So it's free for a woman applicant to approach any court on any matter, whether it is land disputes, whether it is defamation, whether it's anything you have in mind. They can go to court and they don't have to pay court duties. So that opened a floodgate of litigation, because what happened, suppose I have a problem with a bureaucrat or with another politician or with somebody else, I will not go to court. I will file a defamation case of 5 crores, but I'll make my mother or my wife or my sister or my daughter, somebody else file it on my behalf. And if I have 3-4 relatives in 3-4 different places of the state, all of them can file on the same thing simultaneously. So these were things that I tried to address in that bill. The press council, to be fair to them also, has, as Mr. Vaidyanathan, I think, had said earlier, the ministry that is supposed to be the target or is the subject where the judgment, against whom the judgment will go, that is the ministry that funds the press council, the Ministry of Information and Broadcasting. The minister decides which members, one of the Rajya Sabha and the Lok Sabha, will be members in that. So usually it is the ruling party which puts its members in the press council. Then there are representatives of the media. That again, the secretary, obviously on the advice of the minister, decides who will represent the media in the press council. Then there is a judge, a retired judge, who comes and adorns the chairman post in the press council. Now, I am sure all our judges are very learned, very experienced. But when it comes to specific things like the earlier guests also mentioned, when it is about electricity or when it is about, now we are having cyber crimes, when it is about technical issues, even media is a technical issue. So when you have a judge who has no idea about the style of functioning of media, and that person is expected to adjudicate, not resolve, the press council doesn't resolve anything, but adjudicate in matters arising against the media. The the final result is something that leaves a lot of scope for abuse for various people later on. I would like to give a few examples, but I'll get back to that a little later. So the Press Council, till the first, till this first term of Narendra Modi's government, the NDA 2 government, that was 14 to 19, they gave it a power that if the Press Council got multiple complaints against a publication or any media as such, they had the powers to write to DAVP and to write to other ministries to stop advertisements to that particular media. That was the first time some teeth was given to the Press Council. But that also I found was approaching the problem in a negative manner. It was not with the purpose of setting right what was wrong with the media, because anybody can say anything to be a fake news. What is fake for me may not be fake for you. So fake news itself became a very oft-used term, and the Press Council was kind of, although it got teeth, but later on what we found, the Press Council actually became ineffective in many ways, except where the government wanted to take revenge on a particular media for one particular news or a certain attitude or editorials of that publication or that TV channel or whatever. So again, to refer to Mr. Raja, I also agree with him that it is simply a failure of human resource in India. It is the human element which has done damage, systemic damage to this country. It is us. And why has that been the case? I have my notion. You may agree or you may not agree with me. My notion is, historically, for a very long period of time, we have been subjugated to foreign rulers, and that has changed our DNA in the sense that dissent, like it was, Prashant Bhushan. Somebody mentioned Prashant Bhushan. Prashant Bhushan, when he dissented with the Supreme Court, that became contempt. But when MLAs oppose a government elected under a particular symbol of a particular party, that is considered a part of democracy. So if dissent in the assembly or in the parliament by the ruling party members against the chief minister or the prime minister is a democratic process, so also a lawyer dissenting with a Supreme Court judgment should be considered a democratic outcome. But I would not get into that. I think that's a very heavy subject, and I'm not qualified enough to talk about that. There should be, even for the Press Council, there should be a system where we have professionals who have studied the subject, who have interacted with media for a long period of time, and who know the inner workings of media, the economics of media, how media survives, and how eventually the opinion that the media dishes out has relevance for survival for that media. Suppose I oppose a particular aspect of governance. Now my readers may be those who want to read that particular aspect. If they don't want to read, I cannot force them. They can stop my newspaper or they can switch off the TV channel. So when you say that, no, this is not acceptable, this is very easily you can label somebody anti-national or fake news, then what happens is you are stopping certain thought processes, and in the longer run you are damaging democracy. So media as a whole is, I think, a strong fundamental necessity for a democratic society, and the Press Council could easily become a very effective tool in strengthening media and not regulating it, but strengthening media to be free, to be vocal, and to be active. But sadly, that is not the role that the Press Council has taken upon itself as of now, till now. And it has always been adjustment for a retired judge of of a high court or sometimes a Supreme Court also. I think one Supreme Court judge had been there as chairman of Press Council, but mostly high courts. So they are all looking for these appointments post-retirement. And this is an adjustment post. So when it becomes an adjustment post, then, well, Corona has changed all that, but otherwise it was always touring, how many vehicles you have, what is the office staff, and such things took precedence. That, I don't know, that is probably the discussion today, and you will, all the learned people here will probably cast better light on this. But the Press Council, to sum it up, the Press Council of India is, I would consider it is a waste of money, taxpayers' money, and it is a failed organization, and it needs immediate revamping if we need to strengthen the media. Thank you. Thank you so much.
Thank you, Satpathy. Thank you for giving us the insight on lawmaking processes. We have some questions, and also on the Press Council, we'll come back to some of the issues that you have raised you made a very strong statement saying this is almost like a waste of money, taxpayers' money, the Press Council of India. At the same time, today, we see the Press Council as a sector regulator, and with the media the way it is in our democratic setup, and what you said about multiple cases, and we don't see how. I mean, we still need to see how Press Council can be strengthened, because you would still need some kind of a regulator in the sector which is not behaving like a court, but would have other dimensions to solve problems that people may face, whether it's fake news or it is advertising revenues, or there are issues concerning defamatory aspects, like you said, multiple cases being filed, people rushing to the courts for stay orders. These are matters which possibly there needs to be some legislative teeth given to the Press Council, which we thought in our initial review of the Act, we're lacking some, it doesn't have the teeth. We'll come back to that. Now we have some questions. What I'll do is I've taken printout of some of the questions. I'll put it to the panelists. And then we also have certain very senior people in the audience. Mr. Suthita Bhattacharjee is there. He's the chairman of the West Bengal Commission. Mr. Bhattacharya, if you want to say something on, unmute him. If you have any comments on the overall discussion and the structure that we've had before I start taking questions. And yes, you are unmuted. So if you have any comment, because you also been a senior bureaucrat, Mr. Bhattacharya today is the chairman of the West Bengal Commission. And before that, he was chairman of Coal India. And he was also chairman of Singareni Colliery. So if you can share with us on the initial, what we flag are issues with commission, since you are in the thick of it now, if you have any comment that you wish to make.
Thank you, Sanjay. And it has been really a great pleasure in listening to the very, very competent panel. I would only like to comment that when we have been talking about regulator, we have been talking about tribunals. My experience, I will leave aside the regulatory and power for a minute. I will take, Mr. Raja is my very revered senior, Mr. Vaidyanathan. We had been, I was in the Andhra Krishna Water Dispute Tribunal. I was the administrative secretary. I will refer to the Central Empowered Committee route of the Honorable Supreme Court. And when all the kinds of, the clearances used to be given on the recommendation of the CEC, and the CEC started becoming like a court. And ultimately, I won't like to go beyond. I thought that was a super regulator we had seen, which was completely authorized by the highest court of the land. I would definitely like to get some comment from very respected Mr. Vaidyanathan ji.
See, I think the exercise of appointing the CEC and the amicus in those environment matter, I think the court virtually delegated its powers in regard to adjudication. I think it was a sorry situation. And hardly any criticism could be made of what CEC had submitted by way of report, and all the applications had to be routed through amicus. Amicus appearing will speak the voice of CEC, and courts very, very rarely interfered with whatever the CEC said. I think that was not a welcome methodology that was adopted by the court.
I will just, we have some representatives from industry who are stakeholders in the tribunal system, and they are primarily in the power sector. Naveen Munjal is there from CLP. Naveen, would you've seen the tribunal system closely as a stakeholder, and what is it? What is your takeaway? What is your comment? Have we failed you as lawyers, as tribunals? Or as a stakeholder, because you have immense stake in the system. And where do you stand on this? Before I come to the lawyers, I want some perspective.
Thanks, Sanjay. And I must confess that the experience at APTEL, because that's where we've actually spent the most time on in the recent few months, has been rather negative, I must confess. And the issue, therefore, that I want to talk about is what some speakers spoke about a specific team of people, a specific arm to be recruited for such specialized tribunals, and that makes so much more sense, because I remember we went through a hearing process which lasted a year and a half almost, and then by the end of it, before the judgment actually was written, the member retired, and then we had to start the matter from scratch once again. And then it's been another saga of another 2 years, and we are waiting for the judgment. And unfortunately, I know that another member is on the verge of retirement over the next 2, 3, 4 months. And if we don't see the judgment in the next 2, 3, 4 months, we could potentially see the whole thing getting, the whole thing going topsy-turvy, and it's actually a complete miscarriage of justice. It's been a case of huge delays of the delivery of the justice system, and therefore, the tenor and the fact that we've seen legal luminaries from who've retired from courts, who actually come into the tribunals. They do not have the in terms of the timeline available, and B, of course, we do sometimes feel that there is the lack of understanding the nuances of either the technical or the financial matters. That is all I wanted to say. Thank you.
Thanks, Naveen. These are very important perspectives for us to go back and think, and being part of the system, we need to find ways to manage. I'm sure there are no magic solution to this, but it's only through debate and these kind of programs that we can find and take these messages across. I have also Mr. Ravi Chaudhary, who's a very senior from Dhariwal and CESC. Chaudhary Sahib, do you want to say something on this? Because you've also seen the system very closely. And before I take formal questions, I just want comments. So we have Mr. Vaidyanathan, Mr. Raja, Mr. Satpathy, who can also see the anguish, or if you're happy with the system, what are the positives? So I'm sure there are positives also, because if you take complicated matter like Naveen's matter or Mr. Chaudhary's matter to a civil court, where would it be? Now, instead of that, you are before a commission or a tribunal. So between the civil court system, which has also failed us to a large extent, where are we? So, Mr. Chaudhary, would you like to comment on it? Do you have something to say?
Yeah, thank you very much for inviting me to comment. Sir, I will be having only some general comment. I am not going to have any specific questions. So my experience is that the electricity business is becoming very complicated day by day. And when we are taking any matters even to the court, for it is getting delayed because of various reasons, as Mr. Munjal has said. Things becoming very, very complicated. And sir, the last thing is, sir, even after the court give a justice, given an order, it is not being followed by the person on which the order is supposed to be delivered, and he should comply with. I have got many orders from appellate tribunal also. That's not being ultimately being followed by the appellant, by the on which the order has been served. So I'm really, at sometimes we are really getting frustrated that then why after 2.5 years, 3 years, 4 years, we got an order, even then that is not getting complied with. So where do you go? You know, the change in law matters. After so many years, we have got the not being able to make things, ultimately I'm not getting benefited. So these are some kind of very painful areas. I do not know whether it is the right forum to address or not. That's all, sir.
Thank you. Mr. Vaidyanathan sir and Mr. Raja sir, can you please, Mr. Vaidyanathan first sir, can you comment? I mean, this is what Naveen said about the delayed retirement, which you flagged, that 3 years is too short in your initial remark. And people are retiring, matters are not getting heard. At the same time, Mr. Chaudhary says, even if you have a judgment, you can't enforce in a tribunal system because it doesn't have the seal of the court. The seal of the High Court is missing. So people, even bureaucrats, don't take it very seriously in that sense. Do you have a comment on that?
See, on the first aspect, I feel that the tenure should be fairly long. This 3-year or 5-year period is really of, it doesn't help. And we can have persons who are taken at the age of 40, 45, career tribunal members, chairmen, and there should be a common appellate forum to which perhaps they can look forward to going, and then maybe to the High Court or Supreme Court. I mean, that's the kind of thing that one should really envisage, and therefore, see, the whole object of tribunalization was that there were huge areas in the normal system of courts. And it was thought that if you have specialist members, they'll be more focused, more aware, more knowledgeable, and therefore there'll be quick disposal. But unfortunately, this has not happened. And that's an unsatisfactory state of affairs. Now, therefore, a longer tenure will certainly be useful. In regard to the enforcement, see, the Water Disputes Tribunal, for example, an amendment has now been made that the award of a Water Disputes Tribunal, when it is notified, it will be a decree and it can be enforced. It will be a decree of the Supreme Court and it can be enforced. Therefore, any award, any order of the tribunal should be, once it is confirmed in the appellate forum or whatever it is, that should be treated as a decree which can be enforced through the appropriate execution process if need be. And most in electricity disputes, mostly it is the public sector undertakings which have been failing to follow this. And I think there should be a system of imposing heavy penal costs, not just on the organization, but on the individual who is obstructing the enforcement of this. If that is not done, and if people are not proceeded against in that manner, I think it's going to be very, very difficult.
So Raja sir, if you can also.
Yes. I'll restrict my experience again as chairman MERC. The chairperson of these commissions also have an administrative role. They are the CEOs of the organization. So I recall that we used to have administrative meetings, and during my tenure, we had a system by which a member will stop hearing new cases. That is, he will not sit in new cases roughly about 2 months prior to his date of retirement. Or we used to take a review of how many cases where judgments are still due. The attempt is we should try to give all judgments where a particular member is involved before his retirement. And if the number is a little large, we ask him not to attend new cases. Cases where he is already in the bench, he will continue to hear, but he'll stop attending new cases so that he gets time to complete that. And I think it worked quite well. There could have been some exceptions, but I think by and large, we tried to minimize these cases which had to be heard all, literally ab initio. But I remember a very interesting case where I didn't have a third member. I was just myself and one other member, and that one other member recused himself in a particular case because he was an executive director of the distribution company and he was involved in negotiating and signing a particular contract. So he brought it to my notice and said, I would like to recuse myself. So he recused. So I was a single man who had to hear. It was somewhat a sensitive case. So when a new member joined, I permitted to the new member because I didn't want to hear it all alone. And we had to restart a certain number of hearings. So there are these peculiarities which arise. I think it is the duty of the appointing authority of the government to ensure that vacancies are filled up fast. There's another problem that even though the law, like the Electricity Act says, 4 months, I don't now remember, 4 months when a person is due to retire, the process should commence of appointing the selection committee, appointing a judge who will be the chairman of the selection committee, all that, so that a new member is in position. But there are a number of cases where the government just sits on it, doesn't do anything. In some cases, the consumer representatives go to the High Court just to kind of nudge the government so that they do something about it. So keeping vacancies unfilled, well, one of the reasons it happens looking from the political point of view is, particularly when coalition governments are ruling in a state, the coalition partners also bargain on these vacancies. 2 posts of information commissioner is vacant. 1 post of some other commissioner is vacant. 1 membership in the water regulatory commission is vacant. 1 membership in the electricity is vacant. These 6 posts we will decide together. Each of the coalition partners must have a say in this. This is what happens in actual ground. That everything becomes a bargaining between coalition partners. There could also be other reasons, but this is not something which can be considered as good governance. Coming to the issue of even after getting an order from the appellate tribunal, something is not complied with. Normally, appellate tribunal high court orders are complied with, but there could be delays, particularly when it comes to state discoms. The hard reality is state discoms are in perpetual cash crunch. I think if I recall from memory, the total deficit of all the state discoms of India today is about 1,24,000 crores. 1,24,000 crores is the total deficit of the state discoms. Of course, the state discoms do have an umbilical cord with the state government. But one must remember that just like the government of India, the state governments also have a revenue deficit. And unlike the government of India, they can't print notes. They have what is called a ways and means limit. And if they exceed the ways and means limit, the state government's checks will not be honored. So what really I realize that the job of a finance secretary in the state is not really a finance job. It is a day-to-day cash management job. And the same thing happens with managing directors of state discoms. There are contractors bill spending. There are bill spending of wind generators who have not been, a wind generator has to necessarily pump in his electricity to the grid. He has no other choice because he is directly connected to the distribution network, not even to your transmission network. So the electricity is pumped in, but he gets his dues, part of his dues, at the sweet will of the discom because the discom doesn't have money. So then how is this prioritization done? Somewhat arbitrary. That is where political pressures come, telephone calls come, inke paise de dijiye, pay off this contractor first. These are realities. When even after the so-called unbundling of the state electricity boards have happened in form, not in substance. It still continues as a department of the government.
Can I take some questions which have come in? We've taken, we have only 4 or 5 questions, so that I know we are exceeding our time limit, but I will, since the questions have come in, I think it's my duty to put it. The first question is from a law firm, VC Niyaman, which says, do you think the bureaucratic approach of our government in policy making and dominance of bureaucratic lobby?
Can you repeat the question because we lost your voice for a little while?
Okay, sorry, I'll do that again. Do you think that the bureaucratic approach of our government in policy making and the dominance of the bureaucratic lobby in selection of tribunal members has an impact on the independence and approach of the tribunal members? Is it a problem of law or personality of members who man the tribunals? The second part of the question is what Mr. Raja had said about the individual. But is there a problem with the law? Is the question. And do we need to find a way to tighten up the law? And is there too much of bureaucracy in the whole process? Can we get the bureaucracy out of the appointment process? That's the question.
See, I just want to give an illustration. We all were somewhat gaga when the Advocate on Record Association petition in regard to taking the selection of judges from the political bureaucracy away and then vesting it in the judiciary. What has happened? The collegium of the system of appointment in regard to selection of judges has not been all that rosy as one expected. But what happens is, in spite of all its flaws, once the judge who comes in is there, he has a long tenure. Whatever influences are there at the time of initial appointment, at the kind of overwhelming influence that might have been there at that time. Subsequently, because of the assurance of independence and long tenure and security of tenure, I think the persons change, the office changes, the persons change, and I think there is a greater independence exhibited by the judges. This is what I have seen, and that is why even now there is so much of faith and confidence in the system of judiciary. And if therefore we don't have this 3-year tenure in regard to tribunal members, whatever be the selection process, it should certainly be improved, should be more independent. But even if there are any faults, with a sufficiently long tenure and with a guarantee in regard to independence and a security of tenure, I think there are greater chances of more acceptable, more satisfactory tribunals function.
Thank you, sir. Mr. Rajan, do you want to comment on this?
I think this could be a formal subject for study, but I will now study means over the last 20 years, who are the regulators, who are the tribunal heads, what was the source, what is the general performance. But my experience is they have people who have performed well, people who are former finance secretaries have become RBI chairman who have performed very well. There are good examples and bad examples. I won't say that being a retired bureaucrat has made him under the influence of a particular person. There are good and bad cases. It can certainly be thrown open to outsiders also, but not to. The point is, there is a system. Understanding the the recent draft amendment to the Electricity Act says there should be a common selection committee at the center. But suppose, let's take Maharashtra. Suppose none of the members and the chairperson understands Marathi, he will not be able to do public hearings. So one has to make a balance in many of these matters. A certain inside knowledge is useful. The fear that total inside knowledge will influence him totally. A second problem on the electricity sector, which I feel is, let's take the government of India. The power ministry is in charge of policy making in the power sector. One is it has the secretary, who is typically an IAS officer or an outside expert. Then there are joint secretaries who are all on limited tenures, let's say a maximum tenure of 5 years. And then the advisory staff, by and large, are on deputation from NTPC and Power Grid.
One question.
So there is a bias. This bias gets that filled in. The rest are clerical staff. The clerical staff is internal, but they don't play any role in policy making. There are these generalist joint secretaries, and then you have people on deputation from state energy departments. Almost every question that is answered in the Legislative Assembly gets sent to the energy department, and energy department refers it to the distribution company, because they don't have independent people to give advice. So there is a conflict of interest in which arises knowingly and unknowingly. A bias and conflict of interest does arise in such situations.
We have a question from Mr. Satpathy. There are two questions actually. One is on this. With the investment of Microsoft, Google, and Facebook in Geo, what do you think will be the future of net neutrality in India? This is a question from Tushar. Tushar is a friend of ours, who's a lawyer in Bombay, JSA. And this is a question from Mr. Satpathy. Was I audible? You are muted. You are on mute. Mr. Satpathy, you're on mute.
Yes.
Yeah.
See, I have been noticing that, and now even Amazon, when Jeff Bezos came to India, nobody wanted to meet him. Then Mr. Piyush Goyal very bluntly said that he's not doing a favor by investing in India, and he was sent packing back. That was sometime in early this year, I think January 2020. Then he probably found a key, and he has opened the door just like Google and Facebook did. And today's news is Amazon is investing and buying 9.9% in Reliance Retail. So similarly, when big players like Facebook was one of the biggest proponents of eradicating net neutrality in India. They have another role in the US, but here they played another role. And the government, the first government of Narendra Modi at that time, supported it very much, and they were very keen. But we had a TRAI chief who was balanced and took a very practical look at the problem, and he put his weight for net neutrality and all of us who are fighting for it. So I believe that in the long run, Jio, the way it is more like a toll gate now. If you want to enter certain part like a Saki Naka or some Naka, it's a toll Naka now. And to come in, you have to cross through that gate and you have to pay the toll tax. When that is happening with Jio, I think in the long run, we will be damaging net neutrality, and we will be constrained in our outlook, whereas the whole world is now opening up. So I have my fears, and I do not see anybody who is even thinking in these lines. I am happy the lawyer friend has raised this question. And I think in the coming days, and not too far away, we will be seeing a real threat to India's net neutrality and the position that we are in now.
We are looking at you to start writing editorials on this. Where do we go? We need the media to kind of bring this up. There's another question for you before I come back to the tribunal. We are playing this tribunal versus the press council a little bit. And this is from Mathurgup Mishra, who's a lawyer from Puri, who's now in Delhi. And Mathurgup says this press council of India has failed. Now, what is the solution? What do you have in mind as a way forward?
If you would have read the Press Council Act, the act is superb. The act is very good. See, I'll give, may I veer off a little bit? Mr. Raja raised this issue first about the people who man the offices or who position themselves on the chair. I remember we had one chief election commissioner quite some years back, 2 decades ago, who suddenly clamped down and wanted to pose that he is bringing in good conduct as a part of election process. He wanted to make the sub-collectors and the collectors responsible for the elections in as much that all the MLA candidates or the MP candidates will have to report to the collectors or the sub-collectors on a daily basis on their spendings, on very minute details. At that time, I was very happy because I thought that good, this will cut down the expenses during election, and maybe this man has good intentions. But later on we found, once that man left the post, then he went to Gandhinagar and fought against L.K. Advani. Then he wanted to contest for the President of India. So his whole approach to the election process and the difficulties got watered down by that single personality's true exposure of his intentions. Similarly, the Press Council Act, as is the Election Commission, the Press Council Act is very good. I have read it a few times because I have had to face the Press Council a couple of times. The Act is perfect, but again, it is the people who man it, and they are the people who are nominated by the Ministry of I&B Government of India. So the minister and the secretary. These are the people who populate the or decide who will populate the press council. And when we have people who are retired, who are not actually media people but posing as media people, who are politicians, two members of parliament who are posted there, who are politicians but they have no interest in media or in the freedom of media or in the whole superstructure of democracy. When you have people like that, obviously the act, no matter how good it is, it doesn't deliver. That is what I see in the press council. That is the problem. So where do you get the people from? Do you create them? Do you get AI to function? What do we do? So it is a real problem. And I honestly do not think there is a ready-made answer that I can give, but I can only hope. See, I am also not in favor of taking in younger people who will have long tenures in one post. You take in somebody at the age of 40, 45, and they have a 20-year run in that post, then their biases, their colorings will start affecting the institution also. And the institution not of something like a press council, but the whole media as such. So that also is a big danger. You have to have a balance of people who will preside or who will be members of the press council for a certain amount of time. The government and the courts have to relinquish certain things like defamation or other controls to the press council. They will not listen to it. They will not listen to these cases. They will compel, they will tell people, tell the litigants that you go to the press council. Once we create a culture, an ecosystem which will encourage such things, maybe the people who will be presiding on the press council, they will feel more responsible, they will feel more answerable, and they might start functioning once we allow them to and once we put more work on them. That is the temporary solution that I can think of right now.
Thank you. I hope some of the questions are getting answered. Yes, I know these areas are complex and there is no straight-cut solution to it. All that we are doing now is to put thoughts together. We are making notes and we will come out with some kind of a document to carry this forward and crystallize our various views. In this context, I just want to highlight that which was mentioned earlier about enforcement of judgments. There is a legislation that was made in UK in 2007. It's called the Tribunal Court and Enforcement Act of 2007. Now we are looking at that from the SOLPO perspective to see how a similar kind of an overarching legislation may be required to make certain things, to bring in certain uniformity in the administration of tribunals. We will come separately circulate a paper on this. We'll take some time because we're still it's still a work in progress for us.
I'd like to just intervene. You see, the recent draft amendments to the Electricity Act introduces an Electricity Contract Enforcement Authority.
Correct.
Obviously, to me, it appears to be a knee-jerk reaction because there have been a number of cases after a new government came into Andhra Pradesh. They just simply reneged on a number of power purchase agreements. They said we won't bother about it. And so perhaps to restore confidence of investors, this Electricity Contract Enforcement Authority has been recommended. But actually the problem is there is no power purchase agreement or contract on the electricity sector which will not directly or indirectly impact tariffs. So it's a very contentious thing, whether a new organization should be created. I intervened only to say that this Contract Enforcement Authority has been thought of as a solution for non-enforcement of decisions.
Yes, yes. Since we're running out of time and we've extended our original schedule of 1 hour, now may I only take 1 or 2 questions and I'll close it, but I can promise all the participants that your questions will not be not answered. We will do it electronically. We have taken your questions. I will run it through the panelists separately I'll get the responses collected and send it to you. So your questions will be answered, except that we may not be able to do it just now. I'll take two more questions from the list I have several. I'll just take two more in the order of the time it came. So one, Mr. Rajiv Yadav, Supreme Court AOR, a friend of ours, he says, and this is to Mr. Vaidyanathan, sir, how much is the bar responsible for the poor functioning of the tribunal? Are we as lawyers responsible for it? It's a long question, but that's the core of it.
See, bar has a duty to the consumers of justice. And I think it is not the self-interest in terms of earning professional fees, but to work out solutions. And I think we should be in a position to advise people where they have no case to see how best to resolve it and sort out. I think that is one aspect in which several lawyers are not making much of an effort. I think when you know that at least after the pleadings come in and the documents are seen, that what is your strength, what is the weakness, and you should try to work out a solution. Unfortunately, in spite of the fact that Section 89 CPC is available in the civil courts and can be applied even in the tribunals, where people can meet and try to resolve the issues, no proactive steps are being taken by lawyers for resolving this. That is one failure on the part of lawyers.
There is another question for you, sir, from Apur Mishra. And later, Hemant Singh also has a similar, it's in the same line, same direction. And the question to you, sir, is this. May I request your views on appointment of persons as expert members of tribunals who are primarily from public sector? I'm asking this in the context that most of the regulatory statutes only prescribe eligibility criteria and do not provide that only ex-government or public sector employees can be appointed. But the appointment actually takes place in that direction. So your views on this, yes, and Mr. Hemant Singh has a similar issue where he sees as a conflict of interest in many cases, and this is bothering them as them and the clients.
See, when the first chairman of the CERC was to be appointed, the then secretary, I was the additional solicitor general at that time, and there were some IAS officers who were very keen on being appointed as the chairman of CERC. And then secretary was not so keen. So he wanted to know, does the law require only administrators, bureaucrats to be appointed? And I gave an opinion, no. And that is how an expert economist was appointed as the chairman of the CERC at that time. And they, of course, the sectoral bias, departmental bias that Mr. Raja talked about will come in when you appoint persons who come from a particular department. But there are independent experts who are available, who can be appointed, have been appointed, and they have been fairly successful. I think his tenure as a chairman of the CERC, I thought was fairly good, gave the lead. That's my view.
One question from Mr. Debojyoti Bhattacharya. What are the impediments in setting up of a subject matter specific benches in the High Court for economic and commercial matter other than taxation? Why can't we have special benches? Why have tribunals at all? This is what you started by saying.
Yeah, I think it should be done. It can be done. It has been done in UK now. You have construction in specific industry, infrastructure specific benches, Queen's Bench division dealing with each one of these, and it can be replicated in India, and I think it will be a useful suggestion to be implemented.
The last question for you, then I'll let you go, sir. This is from a young He's a lawyer to be. He's Kanish Dasmapatra. He says this, Mr. Vaidyanathan sir pointed out several shortcomings with how tribunals are set up right now. Retired judges with fixed tenures, trying to replicate courts instead of seeking best outcomes for both parties. Given that these tribunals are here to stay, do you think they will change? And how do you see them actually change? As a country, we seem to act slowly even after identifying the problem. So he's a man in a hurry, I can see that. What is your take on this? He's saying it's taken us so long to identify the problems. And when will we change? I mean, we have so many years to live.
See, there are judges who have the commercial bent of mind, like Justice P. Krishna, Justice Rohinton. I mean, I am not taking too many names, but these are people who have that business feel, commercial sense. But if you don't take such people, but those, I mean, what happens, one of the failures of the collegium system is, and the person who is sitting in the collegium, now, when he himself is the person who has to nominate the chairperson of an electricity appellate tribunal or the telecom disputes tribunal. So they find that, okay, we have accommodated so-and-so, so-and-so. Now some other person will have to be given. So let us make that person the chairman of such and such tribunal. Now, if that is the manner in which appointment is done, that is not going to be very helpful. You have to look at the expertise of that person, the background of that person. And Justice Sri Krishna has been used in, for so many financial and commercial, commission. And he's a person who has done a fantastic job in each one of those. But you don't have so many Sri Krishnas. That is a problem.
One last question for Mr. Raja. Sir, this is from Nidhi Soni. She's from SBI Cap. And her question is this: can commissions and tribunals not have larger staff of experts? Could the existing staff be offered more training and opportunities? So one additional question. Often the commissions are outsourcing a lot of work to come to consultants. A lot of large commissions are consultants and they are working and supporting the... Now, do you think that's a healthy thing to do? Or should you have your own staff? Or should you get KPMG to support you or EY to support you? Is that the correct way? Because that kind of support is not available to the appellate tribunal when you go forward.
There is a dilemma. I mean, I myself wanted to improve the permanent staff. So I had recruited a number of stipendary regulatory analysts fresh from college, some regulatory officers who had 6 to 7 years to 10 years of experience in the sector, electricity sector. And I had also taken on contract some regulatory experts who had retired from, and done outstanding work in utilities, and tried to put them together. The idea was, in the market, through a proper market recruitment, you don't get the best persons. Because the very good people, they have other options available. They don't see the regulatory commission. Here also a cadre issue comes. Because they don't have that much scope for advancement. Even the biggest regulatory commission is very small. So everybody wants to join an organization where they see prospects for growth. So that is the real problem. I remember that even when decisions were taken that the state load dispatch centers must be ring-fenced, like has happened with POSCO, in the state it has not been done. It is all part of the transmission company. And the main reason is no officer of the transmission company wants to branch out, because the transmission company is a big organization. From executive engineer, he can become superintending engineer, then chief engineer, then some advisor. He sees growth. While if SLDC is carved out into separate, it becomes a small organization. He doesn't see growth prospects. So there is those kinds of personnel dynamics which is taking place. And we still don't have an appropriate solution. If it comes to an all India cadre, then the question of transfers comes in. People in the age group of 40, 45 don't want to leave wherever they have settled because they have children who are in schools or colleges. So all kinds of personal issues are coming up. This I have seen again and again in various assignments of mine, both in the government. In the Atomic Energy Department, we lost the possibility of outstanding uranium mines in Meghalaya. We lost 2-3 years because nobody is willing to go to Meghalaya. They don't want to leave Jaduguda, which is near Jamshedpur, where the uranium miners are there. They don't want to go. In the meantime, those 2-3 years, even though uranium had been explored and found by the Atomic Minerals Directorate, this delay of 3 years contributed to a huge resistance movement against uranium mining developing in that area in Meghalaya. Even now, Meghalaya has better quality uranium than Jaduguda, but we are not able to mine it.
Last question to Mr. Satpathy. This is completely out of the box. And I'm not, this is anonymous. And he says, do you ever think marijuana will be legalized? Completely out of the box.
I hope that the international research that is going into the medicinal aspect of that plant will have a bearing because traditionally Indians have always thought of marijuana as ganja as an intoxicant. But today with the whole world evolving beyond that, see, recreational use is only 3%. The rest, 97%, is medicinal fabrics. You can produce umpteen number of things from that one single plant. And we should take note that marijuana is originally from India, from the Himalayan Terai, that belt. And it has gone from India all across the world, including South America, North America, Canada, everywhere. It has also acclimatized itself to various climates. So the international research, which is happening at a fast pace now, interestingly, they're also doing research on cannabis in relation to COVID-19 cures. If something like that happens, then maybe the government, and I think it is more of a social stigma in India now rather than anything else. But once that social stigma goes and people realize that it has a lot of, you live in Delhi, if you go to Khan Market and you go to one of these cosmetic shops, they are those expensive ones, you will probably get 50 brands of shampoos and face creams and body lotions and everything made out of hemp. So hemp is being researched into, and I think that if this continues and internationally, if they say that yes, hemp is good, if the Americans say it, like they have started saying and the Canadians say it and the others say it, then we will accept that our plant is good. Unless it gets international recognition, we are not willing to accept it. Just like our economists, when they were in India, we didn't recognize them. Once they got a Nobel, then we looked up to them. So I think I still have hope that one day things will change in India once the world accepts that hemp or marijuana or cannabis is a positive element and it can help us in our lives.
Thank you very much. Except that I'm sure the person who asked the question did not have the medicinal purpose in mind. I'll leave it at that.
The recreational part also is fine by me. I have no problem.
I'll let that pass. Thank you, sir, very much. Thank you, Mr. Vaidyanathan, for your time. It's a Friday evening. I'm sorry we did this to you, but thank you for being there. And we will come back to you. We'll have lots of other, we will not have too many webinars. I know the fatigue of webinars is setting in, but we will do some writing and circulating notes and we'll do that. Mr. Raja sir, thank you very much. You've always been there. Whenever I've asked you for anything, you've been there. Thank you, sir, for being there. And Mr. Satpathy, I don't have to thank you. He's like an elder brother, so it's my right over him that I can get him to come. Thank you very much. And I would thank everybody who took this time to participate. This is the first time I've moderated an event. I've never done this. done this in the past. So please
You
forgive.
did an excellent job.
You know,
Done an
any,
excellent job.
any of these, you know.
Thank you. Thank you, everybody.
Thank you.
Thank you very much. Thank you, everybody. Thanks for coming. Thank you.